This is Chapter 4, Lecture Video. Types of Evidence. Chapter 4, Lecture Video. You should have your PowerPoint open and your textbook next to you. Let's look at slide 5, Relevant Evidence. Evidence that makes any fact important to the case more or less likely is relevant evidence. It is probative. It offers some proof a fact did or did not occur. It has a probative value. Let's look at page 90 of your textbook at the bottom. One of the basic concepts of evidence is that only relevant evidence is admissible in court. There are situations, however, in which even relevant evidence may not be admitted. That's when evidence was obtained in violation of the defendant's constitutional rights. Page 91 at the top. Something is relevant if it tends to prove or disprove something that is disputed in a case. Slide 6, Objections and Relevancy. Evidence that is not relevant is not admissible. An attorney may object and require the judge to rule on the relevancy of any evidence. If there is no objection, then no proof of relevancy may be offered. Bottom of page 91 talks about probative value. That's a key to admissibility. That means that evidence must make it appear that a fact is probably true. Sometimes there is one piece of evidence that conclusively proves the case. That's rare, though. There's usually a variety of pieces of evidence that, when considered together, convince the jury that the defendant is guilty beyond a reasonable doubt. I like to call it pieces of the puzzle. When you have more pieces of a puzzle, then you have more belief in that overall picture. And when you're missing a lot of pieces, then it's hard to have that puzzle put together. That's just my analogy. Bottom of page 91. Are we ready to go there yet? Yes, I think so. No, we're going to look at slide 6, Objections and Relevancy. Evidence that is not relevant is not admissible. An attorney may object and require the judge to rule on the relevancy of any evidence. I just said that, didn't I? Oh, I'm sorry. At the bottom of page 91, if an attorney makes an objection based on the lack of relevance, the judge must decide if the evidence is likely to have any effect on the jury. And if not, the evidence will not be admitted. This is determined question by question basis during direct and cross-examination. And also the top of page 92, Material Evidence. No, actually at the very top of page 92, those are examples of relevant evidence. Fingerprints on a murder weapon, gunshot residue on the defendant's hands, a defendant was the last person seen with the victim before their death, and so on. So you can read more about that list. Sorry about that mix-up on what slide I was on. Slide 8, Material Evidence. Evidence that has some logical connection to the facts of the trial and affects whether they can be shown to be true or false. Evidence that has no connection is immaterial and inadmissible. Now let's look at page 92, right in the middle. In practice, relevant evidence is material if it meets two tests. 1, it must be relevant to some fact that is an issue in the case. 2, it must have more than just a remote connection to that fact. Slide 9, Exclusion of relevant evidence. Exclusion of evidence is a balancing test. Judges look at the impact of the evidence. Federal Rules of Evidence 403 is the exclusion of otherwise relevant evidence, and that's page 92. You can see that the Federal Rules of Evidence number 403, the court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. We'll talk about cumulative evidence in a little bit. Slide 10, Typical cases of exclusion. Evidence that is unduly prejudicial due to high emotional impact. Prior convictions of crimes are not closely related in manner or time to the current case. So if somebody had a prior conviction of a crime and it was so long ago and it's not relevant, then that could be excluded, any evidence of that crime, if it's not relevant, because it becomes too prejudicial against the defendant. Evidence that distracts from the main issues at trial, so that could just be some curveball weird thing. Slide 11, Cumulative versus Corroborative. Cumulative evidence is evidence that repeats itself. and it repeats other evidence or other facts, and it's less likely to be admitted because it's already been proven. It's already been admitted. So let's say, for example, on the bottom of page 93 gives a good example. Let's say you have 10 eyewitnesses. Do you need all 10 of those witnesses to come? No. So the judge would decide how many witnesses would they need. You're not going to need all 10 because that's cumulative. Corroborative, however, corroborating evidence, it adds new facts and it confirms other evidence. It links together. It's more likely to be admitted. Page 94 talks about corroborative evidence. It's evidence that supports prior testimony. It's not cumulative. It's different evidence, but it helps support other evidence. A great example is the different forensics evidence that is collected, maybe a fingerprint result, DNA result, firearms tool mark result, things like that, and it corroborates witness testimony. That's a good example. Slide 12. This, if you don't already know this is very interesting, I think, and maybe an eye-opener for you what direct evidence actually is. Direct evidence is evidence that conclusively establishes something as true, if it is believed by the jury. Direct evidence of a fact in issue is always relevant. And let's back that up with circumstantial evidence, then we'll talk about both. Slide 13. Circumstantial evidence is evidence that indirectly proves a fact. It requires the jury or judge to make an inference or a deduction or a reasoning, if you will. It is not grounds to object to the admission of evidence simply by stating it is circumstantial. Let's look at the bottom of page 95 of your textbook and look at direct and circumstantial evidence together. A conviction can be based on either direct or circumstantial evidence or a combination of both. And it's usually a combination of both, but you could have all circumstantial evidence in a case. Either the evidence establishes that a fact exists, direct evidence, or the jury needs to draw an inference based on the evidence in order to conclude that a fact exists. That's circumstantial if you have to draw an inference. It is legally possible to convict a person solely on the basis of circumstantial evidence. Now, direct evidence is like an eyewitness. An eyewitness saw something. A video recording of a crime. That is direct evidence. Circumstantial evidence, where you have to draw a logical conclusion, that could be a suspect's fingerprint in the victim's blood on the murder weapon that was found tossed. That seems like that should be direct evidence, but you have to draw an inference. You have to say, okay, there is no way you would have the suspect or the defendant's fingerprint in the victim's blood on the murder weapon. No one actually saw that. There's no video recording of it. There's no eyewitness. But the evidence is so compelling and strong, even though you have to draw an inference that that would not have happened if that person had not committed the crime. It's still not direct evidence because direct evidence is an eyewitness or a video recording. It's absolute fact. But you see how circumstantial evidence is still incredibly important and powerful. And even circumstantial evidence that isn't so important as maybe the fingerprint in the victim's blood on the murder weapon, which would be very rare to have, something that might not seem as powerful is another piece of the puzzle. That's how I like to look at it. All kinds of circumstantial evidence as pieces of the puzzle that puts that puzzle together to give you beyond a reasonable doubt. Testimonial evidence, slide 15. Defined as evidence given by a witness under oath or affirmation. So somebody who saw something, who gives testimony, that is evidence, but it's testimonial evidence. There are two basic types of evidence, testimonial and real. Real is the same thing as physical evidence. So testimonial evidence can occur in court, before court, in a deposition, but it has to be under oath in order for it to be evidence. Testimonial evidence is critical. The bottom of page 97 talks about classifying evidence as testimonial and real is another name for physical. Top of page 98 defines testimonial evidence that it has to be given under oath. Slide 16, actually let's stop.